Good afternoon, everyone. Can you hear me?
Yes, Rob.
Yes.
We could hear you.
All right.
Yep.
I'm asking only because I've had a nightmare experience at times of not being heard. So, all right, looks like we have everyone. Good afternoon and welcome to our meeting of the Code of Evidence Oversight Committee of the Supreme Court. It is certainly nice to see everyone. I am Hope Seeley and I'm honored to have been appointed to this committee and to serve as the chair by Chief Justice Mullins. I also want to welcome two additional new members, Judge Suarez and Judge Gustafson, both of whom are on the screen. So welcome. They too were recently appointed by our Chief Justice. Additionally, I do want to express my appreciation when I started doing some research on how long some of you have served on this committee. You have actually been on it for many years, and I want to thank you for all of the time that you've put into and your willingness to continue to serve on the committee. And finally, I also want to acknowledge Professor Simon Keir, who serves as our academic advisor, as well as Eric Levine, who I believe is on, who is the reporter of judicial decisions, and their guidance obviously is important to us as well. So thank you for that. And thank you for your willingness to join and continue to be the academic advisor, Professor. So thank you for that. A few housekeeping matters that continue and have always been abided by in the past, which is that please mute your audio unless you are speaking so that we avoid the feedback. And secondly, when you do speak, please state your name as not everyone is always visible on the screen. Okay. I'm going to start off by taking the roll call. So with that, when I state your name, please say whether you're present or some other form that you're here. So be ready to take yourself off of mute. All right, with that, I'm going to start with the judges. Judge Gustafson.
Here.
Judge Youngblood.
Yes, I am here. I hadn't heard you earlier, so I have you now.
You got me now? Good. All right,
Yes.
Thank you. Judge Mazzicott.
Here.
All right. Judge Suarez.
Here.
Attorney Adelman.
Here.
Attorney Bourne.
Here.
Attorney Costello.
Here.
And Attorney Cunningham.
I'm here. Good afternoon.
Good afternoon. And Attorney Gaylor. All right. He's not here yet, but we'll see. Attorney Goulash.
I'm here.
Did I hear here? No?
Can you hear me now?
Very faintly. I'm
Okay.
surprised I could hear that very faint one.
Yes, I mean, how about now? Better?
It's a little better.
Okay,
But
I'll try to make
that's-
the adjustment.
All right. I think we can hear you. Can everyone else hear, Bob? Why don't you speak?
Your Honor.
All right. So we'll work on that, but I will note for the record that Attorney Goulash is present and still getting used to this one. Attorney Prescott.
I am here.
All right. And Attorney Steigelfest.
Present. Good afternoon. Your
All
Honor.
right. Nice to see everyone. All right. I would also like to introduce the staff that is on. We have two counsel from the Judicial Branch Legal Services. Lori Petrozelli and Jillian Greenbacker are present. And I want to take a moment to thank them, as well as our Administrative Services Coordinator, Carolina Marin, who puts the technology together along with many other things. So I want to acknowledge them and thank them as well. And with that, we'll turn to our first order of business, which is on the agenda.
Your Honor, I just wanted to, this is just a matter of formality.
Sure.
I just want to formally say we do have a quorum.
Thank you. Thank you for that formality, Lori. I appreciate that. Thank you. And with that, we will start with a motion to approve the minutes from the last meeting of April 5th, 2023, which comes with it an appendix. Is there a motion?
So moved.
Is there a second?
I'll second it.
All right. Second. And we get the moves and the seconds on the identity?
Yes.
All right, and any discussion? All in favor? All right, any opposed? And besides myself abstaining, since I wasn't at that meeting, are there any other abstentions?
I would abstain as well.
All right, let's start with, I see Judge Youngblood, you're raising your hand, you're abstaining, and she's shaking her
Yes.
head yes. Judge Suarez, are you abstaining?
Yes.
And Judge Gustafson, you're abstaining? All right, and Judge Goulash, you're abstaining?
Yes, Attorney Galash, yes.
All right, and is there anyone else that is abstaining? Okay. With that, we will, so that has passed. With that, we will turn to item B under new business, which relates to Rule 6-11C, which is the constancy of accusation. And this is a discussion on whether 611 of the Code of Evidence needs to be amended in light of our Supreme Court's recent decision from February of this year in State versus Adam P. The site for that is 351 Con 213, 2025. The genesis for placing this on the agenda is that in September, I became aware of a communication that was sent to us by the Criminal Jury Instruction Committee, and members of that committee, who are all judges, expressed concern that Rule of Evidence 6-11 needed to be amended to conform to the Supreme Court's recent decision in State versus Adam P. I know I've given you all the materials. I thought it would be helpful to give just a brief overview, and I'll stand corrected. There's some of you who have been on the committee back when Rule 6-11 was amended in order to conform with a prior Supreme Court decision. So I'll certainly look for your input on that as well. But 6-11 subsection C, as you know, addresses constancy of accusation by a sexual assault complainant. The Adam P. decision outlines the history of the constancy of accusation rule, starting with our early common law permitting constancy testimony in a sexual assault cases where the complainant had disclosed being sexually assaulted to others prior to making a formal complaint. The seminal case from 1996 is State versus Troop, and the Supreme Court declined to a request to abandon that doctrine, the constancy doctrine, because the biases against sexual complainants still existed, the court said. But it did limit constancy witnesses to only testify as to the time, the place of the alleged attack, and the identity of the perpetrator, and to not go into the details generally, and only admitted to corroborate the complainant, but not for substantive purposes. And that remained the law for a good 20 years until 2016, when the Supreme Court issued State versus Daniel W.E. And that's when the Supreme Court modified the constancy doctrine. And under that case, a complainant in a sexual assault case would continue to be allowed to testify in direct examination regarding the facts of the sexual assault and the identity of persons to whom she reported the incident. But the court made some changes and said, only if the defense on cross-examination challenges the complainant's credibility by asking questions about delayed reporting or as to any of the out-of-court complaints, then the state would be permitted to call constancy witnesses. The court in Daniel W.E. went on to say if the defense doesn't challenge the credibility of the complainant, then the state may not introduce constancy testimony, but instead the court must instruct the jury that there are many reasons why sexual assault victims may delay in reporting the offense to an official source. And to the extent that the victim delayed in reporting it, the assault, the delay should not be considered by the jury in evaluating the victim's credibility. And it was after Daniel W.E. that this committee and the court changed the rule of 6-11 to what's there currently to match what the court did in State versus Daniel W.E. Then in February of this year in State versus Adam P., our Supreme Court overruled the changes that it previously had made to the constancy of accusation doctrine in 2016 in the case of Daniel W.E. and returned to the constancy of accusation doctrine that was in place prior to Daniel W.E. and including that the jury should be instructed that a complainant's delay in reporting is a factor that the jury may consider in evaluating the complainant's credibility. The Supreme Court specifically encouraged the Criminal Jury Instruction Committee to modify the constancy of accusation instructions, which it has done, and you've been provided a copy of those. So the question for this committee is whether we need to make any modifications. We have circulated recently, and I apologize for the delay in getting it to you, but we did circulate what 6-11 looked like before the changes that were made in 2016, as well as a what I'd call a red line version that the committee made after Daniel W.E. came out. So I'm wondering if, Jillian, are you the one who can share, or is that Carolina?
I should be able to share my screen when.
All right, so
What would you like to have shared?
I'd like you to share the one that I call the red line version, if you know what I mean, the one with the crossouts.
1 second.
And while she's getting that up, one suggestion I have is that this may be conducive to having a smaller group of us take a look at this and make recommendations and report back to the committee. So I throw that out for discussion. All right, so what's on the screen now, and thank you for doing that, is 6-11 subsection C, and the underlined part is what was added in 2017, effective 2018, and what's in parentheses was taken out. Am I correct on that, Jillian and Lori? Okay, all right. So the current version is up there. If you read what's in parentheses, that was before. What was there before was very short, and I'm actually just going to read it because it might make it easier. What was there prior to Daniel W.E. said, a person to whom a sexual assault victim has reported the alleged assault may testify that the allegation was made and when it was made, provided the victim has testified to the facts of the alleged assault and to the identity of the person or persons to whom the assault was reported. Any testimony by the witness about details of the assault shall be limited to those details necessary to associate the victim's allegations with the pending charge. The testimony of the witness is admissible only to corroborate the victim's testimony and not for substantive purposes. So that was 6-11 subsection C prior to Daniel State versus Daniel W.E., which then this committee and the Supreme Court voted to change, which has now been overturned. So that's where we're at. And with that, I'll open it up for discussion, including whether people think we should have a small committee take a look at that and make the recommendations, or whether folks want to do it a different way. So if anyone wants to discuss this matter or have any suggestions. And one of the things is whether we need to make changes at all to the instruction, or whether it should be to the commentary, or whether we think we need to put this on to a smaller group of people to report back in December. Anybody have anything to say?
I'll weigh in. This is Jen Bourne.
Okay, thanks, Jen.
I mean, I do think that the rule needs to be changed, the rule itself, because the rule reflects what was in Daniel W.E., which is not good law anymore.
Yep.
I do think that there's probably some small language things that were changed in the paragraph that you just read that could stay, that weren't overruled. But that's something a small group could discuss and report back on.
All right. I agree with that. Anyone else want to weigh in?
May I join in?
Certainly.
Yeah, sure. I'll echo in large part what Attorney Bourne just said, and I would also just note the commentary as well would have to be amended because it in large part does reference Daniel W.E., and that of course has now been overruled.
I would agree with that as well. So, Lori, if I could ask, do we normally do a motion to have a small group do it, or just table it and have a small group do it?
You could do it by motion, so that's a decision of the committee, at least to refer it to a subcommittee. And
All
then
right.
we don't need a motion for, then people are just free to volunteer.
All right. Any other, before I ask for that motion, anyone else want to weigh in on this at this point? All right, do I hear a motion to have a subcommittee take a look at this?
So moved.
So moved.
All right. Jen Bourne, so moved. A second.
I'll second it.
Tim Costello, second. All in favor?
Aye.
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 Any opposed? Any abstentions? All right, so we will have a subcommittee. I will volunteer to be on that subcommittee. Anyone else want to volunteer to work with me to report back to the committee as a whole? Okay,
It's Mike Gustafson. I'm happy to volunteer.
thank you, Judge. Anyone else?
I'm happy to volunteer, Judge. Jen Bourne.
All right, and Tim Costello?
Myself as well.
All right, anyone else want to join us? 4 sounds like a good number, but happy to have a 5th or 6th. All right. Thank you. All right, the next item that we are going to be discussing is item C under new business, which is a discussion relating to the burden of persuasion as to motions in limine and whether a rule is needed. This is an item that former Judge Prescott asked to be placed on the agenda. So I am going to turn it over to Judge Prescott and ask him to frame the issue and begin the discussion.
Sure. So I discovered this problem when I was on an appellate court panel in a case called Stanizal versus Hunt. In thinking about the issues in that case and looking at some of the case law that the author of that opinion was relying upon, I identified what, at least in my view, I think is a problem with our laws relating to motions in limine. Typically, the proponent of evidence has the burden to establish its admissibility. So if there's a proper objection at trial to the admission of a piece of evidence, the objector typically will state the legal aspect of the objection, and then it becomes the burden of the proponent of the evidence to make the evidence meet an appropriate rule of admissibility, or argue that it isn't excluded by some rule. In the situation where a motion in limine is filed, and I typically think of a motion in limine as being a beneficial proceeding in that it can help frame and limit the issues before trial, saves time for the court, for the parties, and most importantly for the jury to have as many of these evidentiary issues resolved before trial as possible. So in my view, you typically want to encourage parties to file motions in limine. And I'm worried that our law actually discourages it in this sense. In this prior, in Stanizal versus Hunt, the court said that the burden, if someone files a motion to exclude evidence prior to trial, the burden is on the party who filed the motion in limine to demonstrate that they're entitled to relief under the motion. But that, in many instances, risks switching the burden from the party who would have the obligation to prove the evidence admissibility at trial onto the party who's seeking to exclude it by a motion in limine. Without going into too much details about whether or not why I didn't say anything in Stanizal versus Hunt about this issue, I was concerned that the case that the author of Stanizal was relying upon, which was a 2003 case called Mena versus Jamin. I look back at that case, and in stating that proposition, the appellate court relied upon two out of Connecticut federal court, district court opinions that, you know, aren't our law and I don't think are really applicable. It seems to me aren't kind of a wise policy, doesn't advance the policy of encouraging the use of motions in limine. It seems inconsistent with other evidentiary rules and cases that we have, for example, with respect to motions to exclude evidence under Porter, scientific evidence under Porter. The party that would be seeking to have the evidence admitted wouldn't have to file that motion. Wouldn't have to demonstrate the admissibility of the evidence. So I thought it would be wise to have a discussion about whether or not somewhere in the code we want to clarify and suggest that basically the Supreme Court overrule these two appellate court cases with the adoption of a rule that addresses this issue.
This is Kim Massica. I don't disagree with the proposition, and I think that there are very astute observations. My concern rather is whether or not we should or can address this issue, whether it's even within our imprimatur. And the reason why I say this is sort of stepped analysis, generally speaking, as I understand it, the code does not cover what happens in motions in limine proceedings under 1-1D2, which incorporates 1-3. So they're generally preliminary questions about the admissibility of evidence, and we say that, you know, we exclude that consideration. Also, we don't address any other burdens of proof or persuasion in the code at all, except as far as I can find the reference to State versus Porter, where we mention in the comments something about the burden, as I recall. I'm not aware of any other place in the code where we talk about burdens of persuasion or burdens of proof. And I'm also very concerned about what we would be doing mechanically. So if we suggest to the Supreme Court that we establish a rule that regarding some bit of evidence that has never been a rule of evidence, being considered for the code, at least for purposes of a rule of evidence, are we asking the Supreme Court to do something that they don't have constitutional authority to do? And this is, you know, I'm just throwing it out there. I'm not saying I at all analyze this, because they make clear in State versus De Jesus that they have the common law authority to do whatever they think is appropriate in cases where there is a controversy about evidence, whether or not it's consistent with the code. If we ask them to adopt a rule that's inconsistent with what they've already done from a common law perspective, with it being outside the context of a case, is that constitutionally appropriate? Just throwing it out there, and there are probably simple answers to all of these things, but those are my preliminary concerns about addressing this issue.
Can you hear me now? It's Bob Delage. Can you hear me?
Yes.
Yeah, first of all, I think it's great that we're discussing it. Judge Prescott brought up this.
I can't hear him.
You can't, and I don't know what I can do here. Let me just see. All right, am I any better now, or are you still having trouble hearing me?
A little bit.
Are you okay?
Go for it.
Okay, go for it. Well, I think that Judge Prescott brought out a good practical problem, and I tend to agree. It might be more of a practice or a procedure that we have to deal with, that, you know, certain things have emerged over the years, certainly in the criminal court, with motions to suppress, for example. It's kind of understood. You'll get an opportunity to have a judicial proceeding and an opportunity for it to be an evidentiary hearing. And it doesn't happen way before trial, but as we get much closer to a trial. It's a huge problem that I see as a defense lawyer, where we're doing the court a favor to a large extent by bringing the issue to the court's attention as far in advance of trial, so it's not going to take up, you know, the magic words, the precious trial time, and inconvenience jurors, when there are legitimate and time-consuming issues tied in with some of these motions to suppress. And I think there is, if not officially, an unofficial shifting the burden to the person who brings the issue up, and to prove that they're right, rather than, for example, for the state to take on the burden of establishing the relevance or the admissibility of the evidence that defense is seeking to exclude. There's an emerging, in some of the jurisdictions, practice of judges having a good gap between the selection of a jury and the start of evidence. It's not uniform, but it really does address these issues in the manner that they should be addressed, without a premium on time that we have a jury sitting in the jury room while we sort out what can at times be a really need for some sort of briefing on some of these issues. And I'm biased. I feel that defense is always put upon, but you know, a bit of, well, damned if you do, damned if you don't. You know, if you just sit back, you have the advantage, I suppose, of maybe being better prepared to argue your substantive point when you raise the issue in the middle of a trial. But I think there is a gradual kind of shifting that has occurred, where the person who files the motion then is viewed as the one who has the burden of establishing why it couldn't be kept out, rather than reverse. But I agree. I don't know that it falls within the purview of the rules of evidence as much as it does in a change in the practice rules, or some understanding that motions that will likely require some form of briefing or some sort of evidence, that doesn't happen in a trial, and the burden potentially be placed on the defendant or the party who's seeking to exclude something that they anticipate the state is going to try to offer.
All right. Thank you, Attorney Goulash. Any other comments at this point, discussion points?
So if I could just respond to Judge Massicott. So I think I don't see a separation of powers problem here. The Supreme Court, by adoption of the Public Act in, I think it was 2014, that kind of resolved the De Jesus separation of powers issue, basically gives the court two ways to amend the code. They can amend it through their common law adjudication, and then typically we recommend a rule change to mirror the code to the existing case law, and we're talking about that with respect to this new constancy case. So they can do it through their common law adjudicatory power, or they can do it through amending the code itself. I think they have full constitutionality, full constitutional powers to do both, without stepping on any of the other branches. And I think that the bigger question is whether or not, and I agree with you, Judge Massicott, that there are very few code provisions dealing with procedural issues like this. These tend to be typically substantive rules on the admissibility of evidence. So perhaps it would be wiser to address this problem through an amendment to the rules, the practice book rules. I could see doing it either way. But I don't think there's any constitutional impediment to doing it by the Supreme Court adopting a code provision that discusses this issue.
If I may just respond to that, I certainly don't doubt you. I just wonder a third option here, about a third option, which is just to let it develop in the context of a case or controversy, so that it's not being decided in the abstract. There might be things that, at least I haven't thought of, that might make it compelling for one side or the other. Just a thought.
When the Stanziali case came down, and I covered it at the Connecticut Trial Lawyers Association annual meeting, I was very reluctant to suggest tactically to my fellow plaintiffs' lawyers that perhaps you didn't want to file motions in limine because that case says it changes the burden of proof from the proponent of the evidence to the person filing the motion in limine, which is a big disadvantage in winning the evidentiary issue. So I was reluctant to go that way because I think we all agree that motions in limine make trials move much more smoothly. They're good for the judge, for the lawyers. The issues can be fully briefed. You know where you're going before you stand up an opening statement if they get decided. But I did reluctantly point out to everyone that when Stanziali came down, this statement in Stanziali that the burden, once you file a motion in limine, the burden of proving not admissible on any basis is now the person who filed the motion, whereas before it was the person who was offering the evidence. I happen to think it's wrong. I don't think there's a problem with the Supreme Court because it's only an appellate court case. And I'll go one step further. The Mena case on which it relied, that Judge Prescott just referred to, which relies on 2 out-of-state federal court cases, doesn't say that. The Mena case was a motion to preclude an expert witness. And the standard there, you all know it's a 3-part test. The third part is that the person seeking to preclude has to show that that party is prejudiced. And in that, what happened in that case is the plaintiff didn't disclose her expert. So the defense came in and the defense said, I want to preclude this expert because never answered the interrogatory as to the substance of the opinions, specifically on causation. And when the judge got to part 3, is the defendant prejudiced? He said, yes, we're in the trial now. So, and motions to preclude expert testimony are not really evidence things. In fact, they're the opposite of the rules of evidence. Our rules of evidence are designed to aid the search for truth, to hopefully make the evidence as reliable and trustworthy as it can be. Motions to preclude experts for failure to disclose, not that the testimony is not reliable, not that it's not trustworthy, but that the lawyer blew it and didn't disclose the expert possible. We're reluctant to preclude, and therefore we require prejudice. So reading Mena to say that in a motion in limine, the person filing the motion should now have the burden of showing that the evidence is inadmissible, I just think Stanziali is wrong. So although I don't know about code versus practice book, my leaning would be practice book, but it is a problem. And I did suggest to my fellow lawyers, maybe you really don't want to file that motion in limine because you're going to get hit with this argument. You've got to now prove it's inadmissible as opposed to the other side. So I think it is a real problem. my leaning would be practice book versus code of evidence, but I really I don't really know.
Just like jump in again for a minute, hopefully you can hear me. That is that, and it is a little different on the criminal side because I think there's quite a variance between just jurisdictions in this small state, as in certain jurisdictions, when you're called in for trial, the trial is starting, you're going to pick a jury, or immediately thereafter going to do evidence. And again, there's an emerging practice, not by practice book, but almost like an informal, we're going to pick our jury, we're going to have kind of sometimes just called kind of a bump and run, where the judge wants to then have, during a gap between the jury selection and the ultimate trial, doing exactly what Bob had just indicated, where there's a certain ironing out of issues in the trial. Then, jurors aren't inconvenienced and jurors aren't sitting back in a room while, oh my God, I didn't realize it was such a big legal issue. I can't make a decision right now. Or, as Bob said, that in the spirit of trying to help the court by bringing up an issue, you end up kind of getting sandbagged by then assuming the burden by having, tried to make it a smoother trial. There's for a long time, it's not in the practice book anywhere, but it has just kind of evolved that, the court is aware that your motion to suppress is likely to require evidence. And so some time is put aside prior to the actual commencement of evidence. But it can be as important in relation to some of these evidentiary issues of, the admissibility of GSR evidence and the changing of the policies within the state lab and the need to put on witnesses, that will take up an amount of time. And by raising the motion, I shouldn't be assuming the burden. And again, it may just be that this is something that's taken up at the next judicial conference, as in to have some uniformity, as in what's the best vehicle to make it clear that a lot of these issues should be resolved without taking up jurors' time in the middle of a trial, and maybe building in a stronger requirement that certain types of motion in limine really need to be raised in some timely manner, that they can be addressed to avoid the situation we have now. Right now, if you're in a jurisdiction where when you get called in for trial and you're going to start the trial right after the jury selection, you can pretty well guarantee you're going to be inconveniencing those jurors, much more so than in a process that is done a little bit more in advance of starting evidence.
Judge Prescott, I'm curious to know what your thinking is on Attorney Alleman's weighing back and forth on whether this should be a practice book versus a code of evidence. If you have any thoughts on that.
Yeah, I think it would be cleaner to have the Supreme Court do it. First, because they could overrule decisions of the appellate court, and it's really an evidentiary rule, even though it has a procedural aspect to it. I also worry about the judges of the Superior Court drafting and adopting a rule that's inconsistent with an appellate court case. So there's that aspect of it that troubles me as well.
And then I wanted to say something to Judge Mazzacot's point, which is a good one, which is the consideration of letting it develop when there's a ripe case or controversy. Only thing I would say to that is both Judge Prescott and I were on that Stanzielli case. We were not the authors. But look how long it took for that issue to appear in front of a court. I wouldn't want another 50 years to go by before it gets ripe. So I would just point that out there. I hear what you're saying.
And if I could just follow up on that, it's really the chilling effect of the decision, which might lead people not to file motions in limine. And therefore you don't get an adjudication of it, because people are scared away from the issue, so they avoid filing the motion in limine. And they just wait till trial to bring it up where the burdens are going to be where they should be. So it's an issue that may not percolate easily up through to the appellate courts again.
If I can just challenge that notion, and not that I agree with this, but I just would like to challenge that notion a bit, that there's a chilling effect. Even if it's the movement's burden to prove that the evidence is inadmissible, it doesn't necessarily relieve, does it, the proponent of the evidence from establishing at the time it's offered at trial its admissibility. I'm not sure that I haven't thought this through. I'm not sure it takes away the proponent's obligation at trial to bear the burden of establishing its admissibility. And it occurs to me that if this rule is changed, it could also be used for strategic purposes as well, by just filing a number of motions to challenge evidence in order to become more familiar with the other party's case. Because once you file the motion, you're having the other side prove or demonstrate or bear the burden of demonstrating that the evidence is admissible, thereby, I mean, strategically displaying the other side's, in many ways, trial strategy, I think. And it also seems to me that when you make a motion, you are required to have some basis for filing that motion. So is it that much of a step down the road to tip the scales by saying you have to have a reasonable basis for filing the motion, and you have to prove what your reasonable basis is, essentially? I'm just not sure as we sit here that the sky is necessarily falling in the way that we all fear. And I do as well. And I think the point is very well taken. I'm a bit more cautious, especially because it's going to require us to change other rules of evidence that already exist in the practice book. Or excuse me, not the practice book, the Code of Evidence.
Yeah, just to put in concrete terms and you know it better than I do, Judge Seeley and Judge Prescott, but in Stanziali, just to put it in factual terms, the plaintiff wanted to put in his hospital record, and there were 3 references in the hospital record that he didn't want in. So he filed a motion in limine saying, I'd like these references out. There were 16 different references to the speed of his motorcycle. And he took the position that the defendant had not established that these references in the hospital record could be attributed to the plaintiff and therefore admissible as a statement of a party. And the appellate court took the position that it wasn't up to the defendant to show that these were the defendant's statements. The plaintiff had to establish they were not his statements. Very concrete. The second thing was statements seeking medical treatment. And the plaintiff said, well, the defendant didn't establish that those were germane to medical treatment. And the appellate court said, no, it's up to you, plaintiff, to prove that they're not germane to medical treatment. So, I mean, it does have it can make the difference between whether it gets in or not. I can tell you those speed references, one of which had the motorcycle going 50 miles an hour in a 25-mile-an-hour zone. that that it could make the difference. And so I'm not weighing in here because, but I do think that who has the burden matters.
Could I just make an observation? It's Judge Youngblood. I think it may be helpful to just observe that a lot of different judges handle this issue differently. And so you might have a motion in limine and you might hear all the arguments on it and then take it under advisement or defer until the time of trial. And if you do that, then I think the burden is preserved. And I don't think you quite get to this issue. But there are motions in limine and then there are motions in limine. There are different types. Some are important to counsel for jury selection purposes, and they might like to have an answer on something before they start to pick a jury because it might affect the kinds of questions they're going to ask. So I think, to Attorney Goulash's point, it would be interesting to me to see like just how vastly different all the judges are handling these things. And are we in a place, as Attorney Goulash suggests, where we're having a lot of these issues actually decided at the motion in limine stage and not in the context of the trial with the benefit of all of the trial evidence. Some judges will hear the motion in limine and then enter sort of a preliminary ruling, but say, you know, I'm going to enter that ruling without prejudice to your reclaiming this issue once we see the context of all the evidence and make a decision at that time. So I just think it's a really fascinating issue to me. And I think it's super interesting that I think people do things differently. It's interesting to me to hear how differently it may be treated in different places.
All right, any other discussion? All right, Judge Prescott, do you have any suggestions in terms of where to go from here?
I'm not sure. If it were my call, I would probably suggest that a rule be drafted for specific consideration by the Evidence Oversight Committee to consider, so that we had something substantive to talk about. But if people think that this should be referred to the Superior Court Rules Committee, you know, let's not waste our time doing that. And either you, Judge Seeley, or someone can explain to the Superior Court Rules Committee what the concern is and see what they come up with. I could see going down either of those paths. I think I probably prefer the first one.
All right. Based on that, does anyone have any suggestions on how to proceed? I'm happy to.
Judge Seeley, sorry
Yep.
to interrupt you, but I see that Attorney Levine's hand is up.
Oh, I'm sorry. I apologize.
That's okay. I have a quick question as to whether this particular area is covered in the federal rules of evidence or any other similar state code of evidence. I'm not sure that it is, and I'm wondering whether that might be a reason whether to assign it over to the Superior Court Rules group rather than handling it within the code.
That's a good observation.
Oh,
I'm familiar. Sorry, this is Professor Simon Kerr. The federal rules of evidence don't talk about this in a rule, but they talk about it in the advisory committee notes at various points, who has the burden. So it's kind of interwoven into the text, but not in a rule up front.
Can I just jump in? I think Judge Gustafson, I think would confirm what I'm about to say, and that is that on the federal side, there does seem to be a greater effort to resolve a lot of the evidentiary issues that's kind of taking place without a jury sitting in a back room coming up in the course of the trial. So there still is an issue of maybe some disparity between how jurisdictions deal with recognition of the fact that some of these motions aren't just for the sake of raising a motion and aren't just a matter that can be resolved in a 10-minute argument by both sides while the jury sits in the back room. So I don't know to what extent there is, not to say a consensus, whether or not what I'm observing in some courts of this gap between selection and start of evidence and how much that's happening around the state. We get back to whether we take a poll, I suppose, of judges, but it does seem in the federal system, good example being the motions to suppress. I mean, those are heard way before trial. Ours are put off just until immediately starting evidence. But there seems to be a little bit more of an effort to iron out issues that we all kind of know are going to come up in the course of the trial, and the judge has more of an opportunity to address it at some definite time before the actual start of evidence. So it's not a rule as much as a practice, or it's kind of an unwritten rule in one jurisdiction versus another.
Yeah, thanks. It's Mike Gustafson, and certainly be interested if Judge Youngblood, if he can go into the memory banks and go back. But it certainly was the experience in federal court that, because I think it was because of the fact that the judge had the case from day one, that things were ironed out early. I don't know where it came from, whether it was a rule of procedure, a rule of evidence, or just culture. The judges often, if not always, had pretrial orders so that things were done on a schedule. And if there was something evidentiary nature people were worried about, tee it up ahead of time. Again, I sit here now and I was looking for some stuff as we were talking. I don't have it here on my computer as to formally where it came from. Again, a procedural rule or an evidentiary rule. It was certainly the custom that the judge wanted to hear about things early. And you weren't penalized to the extent that you were the proponent of the motion, but you then also felt that I'm bringing it up, but it's not really my point to disprove the negative or to undo no good deed goes unpunished. I'm raising this issue, but it's really for the other side to explain it away. That was all ironed out in the process as well. So I'm sorry I can't be more help, but I think it was certainly the litigants wanted it done early because and I tell here in Hartford at least, been here for a couple of years and had a bunch of Part B cases with on the gun docket certainly, and I was happy to handle suppression motions on cases that they do a pre-trial, and it hadn't been assigned to a judge yet for trial or anything, but I probably did 10 suppression motions last year on gun cases, just so the litigants could know, is the gun coming in or not, and then go from there, as opposed to, well, we'll start picking a jury, or we're going to put it down for jury selection, we're going to figure out what we're going to do. But again, that's, I think, more anecdotal and just a function of what can happen in the particular courthouse and with the particular judges. So long way of saying I'm not sure if it's better to be on the rules, a Superior Court rule or an evidentiary rule, but that's some context from my experience.
I'm not sure if this is consistent with parliamentary procedure, but can I make a different suggestion, or are we still considering Judge Prescott's suggestion?
Go ahead.
I'm wondering if preliminary to forming a committee to draft a rule, we form a committee to gather information, gather research. What does the federal court do on this issue? What other rules might have to be altered? Existing rules might have to be altered. And is there a, perhaps more suitable place to deal with this issue? And then, based on what the committee proposes, then perhaps get to drafting a rule.
Any thoughts on Judge Mazzacot's proposal? Any discussion?
Judge Seeley, if I might throw one more thing out on the table. In the past, this Jack Steigel Fest, in the past, there have on occasion been informal discussions between the chair of this committee and the Chief Justice as to whether the court has any interest in taking on an issue of this kind in this procedure. This is an somewhat unusual approach to overruling an appellate court decision. The court may be interested in doing it and may not be interested in doing it. And I'm wondering if that kind of discussion might be worthwhile. Beyond that, I would simply add that I recognize a significant issue here, but I share some of Judge Mazzacat's concern about whether this is the appropriate place for that issue to be resolved, or whether we'd be moving out of our lane. Right now, the code doesn't really have a section dealing with who has the burden of persuasion or proof as to evidence, at least not in a singular place. I joined this committee a long time ago, but it was after the code was originally adopted, and for some reason the adopters did not adopt the equivalent of a Rule 103 from the federal rules that deals with rulings on evidence in certain circumstances, and I doubt that was an accident. I think that was probably intentional, and I'm just a little concerned about the scope of our assignment.
All right, well taken. I actually like the idea that maybe I should have a discussion with Chief Justice Mullins preliminarily. Judge Prescott, do you have any objection to proceeding that way as a starting point?
No, I think that's an excellent suggestion. I'd be happy to participate in that if you'd like. Yeah, that would avoid some wheel spinning if there's zero interest by the court on doing something like that. So I think it's a good idea.
Could I make an observation? The petition for certification was sought on this case and was denied. So, I mean, it clearly is the status of the law now. I share Judge Prescott's concern that we should flesh these issues out before trial, so the judge is on board and figure out what the issues are. I don't know if you want to speak with the Chief Justice, that's fine, but perhaps a discussion with the practice book chairperson may also be as beneficial. I mean, the Supreme Court already rejected, well, it didn't reject it, it just denied certification on this case. So that's what the law is.
I'll just point out, Judge Suarez, that I don't think that was one of the issues upon which the parties sought certification.
All right, thank you.
No, that's certainly a good point. I agree, is that I think that issue of the motion in limine and the burden of persuasion was hidden in there in some ways. I think Judge Prescott, upon reflection, he has the paragraph in his book where he certainly became concerned about it. And it wasn't until he pointed it out to me after, even though I sat on the opinion, that wasn't a focal point of the opinion at all that I recall. But so be that as it may, I think Attorney Steigel-Fest's suggestion is a good one, that maybe the starting point is for myself and Judge Prescott to have a conversation, and that may inform us on which direction to go. Because it may be.
Judge Seeley, would you like to, if you're at the appropriate point, take a motion, perhaps to table it pending consultation with the Chief Justice and Justice Bright as chair of the Rules Committee?
I think that's an excellent suggestion, Lori. So I'll take a motion as just stated to table.
Mike
I
Gustafson,
second
I'll
it.
make that motion.
I second it.
All right. Second. All right. Thank you. And all in favor?
Aye.
Aye.
Any opposed? Is there any discussion? I guess I should have asked that at some point. Okay. Any abstentions? All right, that's passed. So we will table it and I'll be in touch with you, Judge Prescott. All right. And with that, we go to our third issue, which is a rule relating to, and it's item number D under new business, which is a discussion on whether we should amend section 8-5, subsection 1, in light of footnote 8 in a recent Supreme Court case, State versus Hamilton. And 8-5-1 refers to prior inconsistent statement and uses the term audio tape and videotape. And footnote 8 in Hamilton reads, quote, we recognize that the terms video recorded and audio recorded may today be more technically accurate. In the present case, however, which is focused on specific provisions of the Code of Evidence, we have chosen to describe video and audio recordings by the terms as they appear in the code. And so the person who, as I understand it, has the most knowledge about this is Eric Levine. So if Eric, if you wouldn't mind joining in here on your perspective of this.
Thank you, Judge Seeley. So a discussion ensued between the court and the reporter's office regarding the use of tape versus, which is an obsolete technology, something that hasn't been used in many, many years and often is not sort of part of the, you know, in terms of when this comes up in factual situations, it's really more of an digital audio or video recording. The court was loath to shy away from using the language that was in the code itself, even though that seems to be antiquated language. And so the suggestion here would be to somehow modify the code to reflect, you know, the current technology. And audio recording and video recording is generic enough to cover any sort of recordings that occur at this point. It doesn't point to the particular medium, but it would be encompassing of any type of technology that would be used at this point.
Is there any discussion? I could put up on the screen a mock-up of that rule, and so you could see what it looked like if that would be helpful. All right, I'm seeing some shaking of heads, yes. So Attorney Greenbacker, if you have the ability to do that.
I apologize, just Seeley. Attorney Petruzzelli has it ready.
I apologize. You guys are bringing back my nightmares from teaching a class online for UConn Law School during COVID and having to share documents. But what I will say, maybe I can pull it myself. I think I have a copy of it. So what it would say is literally, instead of prior inconsistent statement, a prior inconsistent statement of a witness provided the statement is in writing or otherwise audio recorded or video recorded. And previously it said otherwise recorded by audio tape or videotape. So that would be the thing. And maybe what we can do is circulate that for everyone to look at for the next meeting. Does that make sense, Lori? To circulate it? Oops, there she goes. Well, there we go. All right. So here is the mock-up. The underlined would be the new. What would be deleted is in brackets. Am I correct, Lori? She's shaking her head. Yes. Okay.
Sorry, I had myself on mute, but yes, you're correct.
All right. So I'll give you a moment to take a look at that. And I do have a question. Do we know that this is the only place in the code that we have to deal with this, or is there other places that we have to worry about? Has anyone looked into that?
Yes, Your Honor. I think in the code of evidence, it is. We are looking into other areas of the practice book, but that obviously is not a subject of this committee. But ultimately, I believe that's the only place in the code, to my knowledge. Please correct me if I'm wrong, anyone.
That was my understanding as well.
Okay.
Eric, does it appear in the commentary to 8-5? The word tape?
I was just looking at that actually, in some of the older codes commentary, and I think that we do have parentheticals to cases that talk about the developments of the law in that area, and how there was a case that recognized that tape recording would suffice. I guess Wayland originally discussed writings, and then its progeny expanded on that to encompass tape recordings as well. So I don't necessarily know that that commentary is going to be obsolete, in the sense that ultimately it does incorporate that. We certainly could go ahead and amend that to say audio recording as opposed to tape recording, but it doesn't necessarily capture what was held in that particular case. So I guess it would probably be good to take a look at the commentary to see if we need to amend that.
All right.
Your Honor, it's Jack Steigelfest. I'm reading this. I'm a little lost as to if we broaden this to say any sort of recording, audio recording or video recording, what do we mean when we start talking about recorded by some other equally reliable medium? I mean, the medium, I think that changes from a tape to something else. What does that phrase mean in a revised version of the rule?
So I think, okay, so what you're saying, because or recorded by some other equally reliable medium is not being changed. You're saying as a result of the changes, what does it mean, right?
Yes.
So statement is in writing or otherwise audio recorded, video recorded, or recorded by some other equally reliable medium.
I can maybe answer that. I think this change to add the recording part of this was changed in 2007, and to be effective in 2008. And I think at that point we did have technology that you could record something without tape. So I think that covers that latter part of that phrase, covers media that does not include tape. And if we are going with audio recorded and video recorded, that may cover
everything.
Everything that we need. So we probably could condense that even further, to say otherwise audio recorded or audio or video recorded, or take that out together and say recorded by other means, other electronic means, or something to that effect.
All right, I think based upon that, I think what we do need to do is take a little closer look at this. So I'm going to ask that someone volunteer to take this one on and draft a rule with maybe, a small committee. Do I hear a motion to have it go to a small committee before our next meeting to come up with a rule, to draft a rule?
Can I just make a suggestion? I don't know if it's consensus. I mean, it seems very well. I mean, I don't see what, it's almost like we're not in any way, doesn't seem like anybody disagrees with the spirit of this. And the only thing by any other medium is we may not continue to call them video recordings down the road, as as words change. So if we eliminated that phrase now, I don't think anybody disagrees with that portion of, or any other. I mean, I'm just saying, it seems to be pretty straightforward that everybody agrees it's probably best that we do have the change to include what is now video as well as audio recording and not be tape recorded. It's not simply limited to tape. So, I mean, it seems to me it's pretty well, either we just agree that we don't need the extra phrase, or the extra phrase doesn't really do any harm. So.
And what about the commentary? That's the
that's
piece
true.
of it that I think someone needs to look
yeah,
at as well.
Yeah.
Because I know I haven't looked at that yet. So I'm just wondering if we should get it all buttoned up and presented, unless Lori and Jillian, that the commentary's been looked at on your end, and I don't think it has been,
No,
right?
we haven't.
Yeah, so I think that needs to be looked into, just to make sure. I looked at it briefly when we were sitting here, but I'd like to have it looked further at. So I'm happy to take that on. So I'll make a motion to have the chair draft a rule and look at the commentary for our next meeting. All right, does someone want to put that motion forward? Unless they want to nominate themselves.
So moved.
Mike
Second.
Gustafson, I'll make that motion. Sorry.
Thank you, Mike. Second.
Second.
All right, all in favor? All right, any opposed? Any abstentions? So carried. All right. Is there any other business besides picking a new date that anyone wants to bring to the attention of the committee? And seeing none, I spoke with Lori and Jillian in terms of a next date. I'm throwing this date out. It's not set in stone. I kept it on a Monday only because that seemed like a good day. But if Mondays are bad because you might be teaching or any other commitments, I'm suggesting that the next meeting be Monday, December 8th at 3:30 p.m. And again, I'm open to different dates or different times. I'm just trying to remember, to me, when I was a litigator, it seemed like afternoons were far better than mornings. And 3:30 seemed to be the better time. So does that generally seem to work for everyone, looking at your calendars? And let me ask it this way. Is there anyone where they know right now that they can't make that particular date? I understand things can come up. All right, so our next date will be December 8th at 3:30. And certainly if there's any other items that you wish to have on the agenda, or that you hear out there in the legal community that you think we should take up from your various groups that you belong to, please let us know and we'll add it to the agenda. But otherwise, hopefully we can address the stuff we've tabled and are working on. All right, with that, is there a motion to adjourn? Or do you want to stay on forever?
So moved.
Okay, thank you. Is there a second?
Second.
It.
All right, all in favor?
Aye.
Anyone opposed? All right, no abstention, any abstentions? None. With that, thank you, everyone, and we'll see you in December. Have a good Thanksgiving. Thank you.
You too.
Thank
Thank you. You too.